Assalamualaikum warahmatullahi wabarakatuh. And every good afternoon to my fellow friends. So today we are from Group 9. We are going to present about the topic consumer protection and hire purchase. Okay. The first, my name is Muhammad Arif bin Muhammad Yusof. I'm going to present about the consumer protection. Okay, consumer protection laws are federal and state statutes governing sales and credit practice involving consumer goods. Such statutes prohibit and regulates deceptive or unconscionable advertising and sales practice, product quality, credit financing and reporting, debt collection, this and other aspects of consumer transaction. The Consumer Protection Act 1999. The Consumer Protection Act is an act to provide for the protection of consumer, the establishment of the National Consumer Advisory Council and the Tribunal for Consumer Claims and for matters connected therewith. This act may be referred as CPA 1999. This act came into operation on the date to be appointed by the minister by notification in the Gazette, and the minister may appoint different dates for different provision of this act. So the Consumer Protection Act provide protection for consumer covering five things, which is the first, deceptive conduct and false representation; two, unfair practice by traders; three, gift price and free gift; four, limited goods; five is safety of goods and services. The first is deceptive conduct and false representation. False is in relation to conduct, representation or practice, includes conduct, representation or practice which is capable of leading a consumer into error. Any misleading conduct as to the nature, manufacturing process, characteristic, suitability for a purpose or quantity of the good is on a first offence under Section 9 of Consumer Protection Act 1999. So the case in this, so the case which is Pankania versus LB Hackney 2020. The claimants purchased property induced by a representation that the current occupants of the property were contractually licensed, whose occupation could be terminated on giving 3 months notice. In fact, the current occupant was in fact a tenant protected under the Landlord and Tenant Act 1954. This was a misrepresentation as to law which had previously been assumed not be an actionable misrepresentation through analogy with case law based on restitutionary claims of mistake of law. The rule bearing recovery for mistake of law was abolished by the House of Lords in Claymore Benson with Lincoln County Council. The High Court held that action based on misrepresentation of law could not be actionable based upon the change of law. The claimant action was therefore successful. The second one is unfair practice of traders. Unfair trade practice refers to the use of various deceptive, fraudulent, or unethical methods to obtain business. Unfair business practice include misrepresentation, false advertising or representation of a good or service, tight selling, false free price or gift offer, deceptive pricing, and non-compliance with manufacturing standards. It concerns the right of the consumer to be furnished with ample information that gives them an opportunity to make the best decision in their interest. Example given, a dealer makes an advertisement in a newspaper for the sale of some goods describing the future fitness and uses of the goods. The description later on turns out untrue and normally a gimmick to attract customer. This would be enforced under Section 9 and 10 of CPA. The third is gift, price and free gift. Section 14 of CPA gives protection against such an offer. The first, where there is no intention of providing it. Second, charge more than the regular price for the goods or services to be purchased. A person who offer a gift price on the free item may impose any reasonable condition on the offer, describe the condition clearly, ensure that the description of the condition is conspicuous, placed near the expression free or free offer as the case may be. The next.
My name is Nur Hazira Pisangaiman. Okay, I will continue protection that provide for consumer under Consumer Protection Act 1999. Next is about limited goods. Based on Section 15 of Consumer Protection Act 1999, required that in supplying or offering to supply goods for sale to consumer, now person should describe the good as limited unless their addition, printing, knitting, crafting, or production is restricted to first, a predetermined maximum quantity. Secondly, the actual quantity ordered within a specific short period of time. Lastly, safety of goods and service. Based on Section 90 Clause 2, state that the safety standard in relation to goods may relate to any or all the following matters. A. The performance, composition, contents, manufacture, processing, design, construction, finish or packaging of the goods. B. The testing of the goods during or after manufacture or processing. C. The form and content of markings, warnings, or instructions to accompany the goods. It comprised 40 parts and 150 sections. The Act applied inter alia to goods obtained by hire purchase. Section 3 of Consumer Protection Act 1999 refers goods as purchased, used, or consumed for personal, domestic, or household purpose and include features versus and vehicle. Financial companies are bound under this Act. In particular, finance companies providing hire purchase facilities should take note of Section 49 of Consumer Protection Act 1999 that set out liability of financial who entered into hire purchase agreement. Next.
Okay, Assalamualaikum. My name is Nur Tazkia. Today I want to present about the hire purchase. Firstly, I want to explain what is hire purchase. Hire purchase is the hiring of goods with the option to buy the goods at the end of the hire purchase term. Hire purchase is one of the most commonly used method to buy cars in Malaysia. The term hire purchase is often also referred to as car loans. In Malaysia, when you take out a loan from the bank to purchase a new car, you essentially entering into a hire purchase agreement with the bank. Next is governing legislation, the Hire Purchase Act 1967. The legislation which governs hire purchase in Malaysia is the Hire Purchase Act 1967. The Hire Purchase Act sets out the forms and content of hire purchase agreements, the legal rights, duties, obligation of hires and financiers. The Hire Purchase Act is administered by the Ministry of Domestic Trade and Consumer Affairs. However, this act does not apply to all items or goods under hire purchase. It only applies to all hire purchase agreements relating to the specific in the first schedule of the said act. Hire purchase agreements relating to other goods are governed by common law. Next is our first schedule. Beside the list of goods in the first schedule is the goods must be all consumer goods. Then for the motor vehicle, it must be namely as invalid carriage, motorcycles, motor cars including taxi cabs and hire cars, goods vehicle where the maximum permissible laden weight does not exceed 2,540 kilograms, and buses, including stage buses. Lastly, for the definition of hire purchase, based on Section 2(1) of the Hire Purchase Act 1967, hire purchase agreement includes a letting of goods with an option to purchase and an agreement for the purchase of goods by installments. Whether the agreement describe the installments as rent or hire or otherwise, but does not include any agreement. A, whereby the property in the goods comprise therein passes at the time before delivery of the goods. B, under which the person by whom the goods are being hired or purchased is a person who is engaged in the trade or business of selling goods of the same nature or description as the goods comprised in the agreements. Next, I will give to the next presenter. Thank you.
Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Amira Akilah binti Zaman. I will continue the presentation. So, who is hirer? Hirer in bahasa we call as penyewa. So, Section 2(1) of the Hire Purchase Agreement, a person who takes or has taken goods from an owner under a hire purchase agreement and includes a person to whom the hire rights or liabilities under the agreement have passed by assignment of by operation of law. Next, who is owner? Section 2(1) of the Hire Purchase Agreement defines a person who lets goods to a hirer under a hire purchase agreement and includes a person to whom the owner rights or liabilities under the agreement have passed by assignment or by operation law. Next. So now, formation and nature of hire purchase agreement. Hire purchase transaction is a contract whereby the owner lets out goods on hire and agrees that upon completion of the payment, the hirer may either return the goods or terminate the contract or elect to buy the goods. A hire purchase agreement includes a letting of goods with an option to purchase and agreement for the purchase of goods by installment. Such an agreement differs from a contract of sale. And lastly, in a good hire purchase agreement, property in the good does not pass at the time of the agreement, whilst in a contract of sale, property in the good pass at the same time of agreement or upon at any time before of the good. Next. There are two types of contract that not include as hire purchase agreement. The first one is a contract whereby the property in the good comprise therein passes at the time of the agreement or upon at any time before the delivery of the goods. Second is a contract which the person by whom the goods are hired or purchased is a person who is engaged in the trade or business of selling goods of the same nature or description as the goods comprised in the agreement. Next, the case listed is Credit Corporation and versus the Malaysian Industrial Finance Corp and ANEL. The fact is Sentis, who is owner, has hired a car to a hirer under a hire purchase agreement. The car was registered under the hirer name and Sentis' right to repose was stated in the car registration document. The hirer failed to pay. Sentis tries to repose. At the same time, the hirer has sold the car to the first dependent. The first dependent has hired the car under hire purchase agreement to second dependent. So the court had is no property in the group passed to the hirer until the hirer has exercised his option to purchase by paying the full amount and fulfilling all his obligations under the hire purchase agreement.
Okay, hi, my name is Mumtaz binti Maswan. So I will continue the presentation, which is warranties and condition. There are certain terms which are applied in a hire purchase agreement. These terms may be warranties or condition. So a condition is a fundamental term of the contract which goes to the very root of the contract. A failure to perform a condition will render the contract significantly different from the contract for. Breach of a condition entitles the innocent party to treat the contracts as repudiate and itself as discharged from performance of all understanding obligations under the contract. Next. So for example of case is Fawcett v. Spears and Pond on 1876 1 QBD 410. A breach of a condition took place. In this case, an actress was hired to sing in the opera, but she got ill and could not perform until a couple of weeks after the premiere. So the help is this breach went to the root of the contract and therefore the opera could repudiate the contract and hire a new actress. Second is Britney VG on 1876 1 QB 183. The breach of contract did not go to the root of the contract and was therefore not considered as a breach of condition. In this case, a singer was hired to sing and perform for a month, which included 6 days of rehearsals. The singer missed out a few days of the rehearsals, but this was not held as a breach of condition and damages were the only remedy available in the instead. Next. So, warranty. Warranty is considered as ancillary or subordinate to the main terms of a contract. A breach of a warranty would only amount to damages and the innocent party does not have the right to repudiate the contract. Example of case is Wills v. Amber, 1944, 1 Lloyds represent 253. A four-breed motorboat had been sold. An innocent statement by the seller that the hull was sound was held to be a warranty which the buyer has entered into the contract. In Reliance Open It, when in fact the hull was rotten but the contract was not substantially different to that which the parties originally intended. He was awarded damages. Next. Other case is Scholar AGV Wickman Machine Tool Sales Ltd on 1974 AC 235. The House of Lords state that a breach of a condition allows for termination of the contract, but the case also shows that even if the parties themselves expressly design a particular obligation as a condition, the word condition is not always conclusive. The circumstances surrounding their agreement may indicate that the parties had no intention of using the word in its technical sense. Additionally, the law itself may give an indication of the status of a particular team. It may be implied either by statute, example Sales of Goods Act 1979, or by a previous judicial decision. Next. So the basic difference between a breach of warranty and a breach of condition is as follows. A breach of condition is a serious breach and it goes to the root of the contract, thus entitling the party not in breach to repudiate the contract and sue for damages, while a breach of warranty is a less serious breach and it does not entitle the party not in the breach to repudiate the contract but to sue for damages only. So the implied condition applicable to all hire purchase agreement has three. First is right to sell. In section, sell the goods at the time when the property is to pass. Example of case is Public Finance Berhad V. Ehwan bin Saring on 1996 when MLJ 331. The Act does not differentiate between new and second-hand goods as far as ownership is concerned. The court also defined the meaning at the time when the property is to pass. It means at the time when a hire decides to pay all sum due under a hire purchase agreement and not necessarily only open payment of the last installment when it becomes due at the time when a hire exercises his option to purchase. Other case is Krishnasamy anak lelaki Supramani v Arab Malaysian Arab Finance Berhad on 2009 7 MLJ 455. The issue before the court was whether the defendant had a good title to said cow when the hire purchase agreement was entered into and whether they could give a good title to the plaintiff. Number two is merchantable quality. Merchantable quality is the goods shall be of merchantable quality, section 7.2, but such a condition shall not be implied. A. Where the hire was examined the goods or a sample thereof as regards defect which the examination ought to have revealed. B is if the goods are second-hand goods and the agreement contains a statement to the effect that the goods are second-hand, all conditions and warranties as the quality are expressly negative and the owner prove that the hire has acknowledged in writing that the statement was brought to his notice. For the example of case is Grant v. Australia Knitting Mills Ltd. The court held the merchantable quality does not mean that the thing is sellable in the market simply because it looks alright. It is not merchantable if it has defects unfitting it for if only proper uses but not apparent on ordinary examination. And the last one is fitness section 70 of HBA, where the hire expressly or by implication makes known to the owner the particular purpose for which the goods are required. There shall be implied in the hire purchase agreement a condition that the goods shall be reasonably fit for that purpose, but such a condition shall not be implied if the goods are second-hand goods and the agreement contains a statement to the effect that the goods are second-hand, and that's all conditions and warranties of fitness and suitability are expressly negative and the owner prove that the hire has acknowledged in writing that the statement was brought to his notice. That's all from our group. Thank you.